Good afternoon. Welcome to Williams-Mullin's COVID-19 Comeback Plan video series. My name is David Burton, and I'm a partner with the Williams-Mullin Labor, Employment, and Immigration section, and I also serve as the regional managing partner of Williams-Mullin's Hampton Roads offices. Today, I'm here as part of the Return to Work Plan to discuss with employers how to mitigate risk for certainly an unfortunate situation that clients are now beginning to face. And that is, after this time that we've been closed and people have been at home, we have learned that perhaps we were not as efficient as we used to be, we're more efficient now than we used to be. And our people have embodied technology much more. And therefore, we may not need as many people as we had in the past. And while we hope that many clients don't have to face that, there are people who are already raising those questions. As in any economy or any climate, employers are always permitted to engage in various reduction in force scenarios, but in the post-COVID-19 world, there's certain things that we all do need to consider, and employers need to focus on very much in order to try to mitigate risk. Anytime that you're going to conduct a reduction in force, it can take place in one of several ways. You could have a just good old-fashioned reduction in force where you eliminate positions, and anybody who is in those positions or one or more people in those positions will have their jobs eliminated. You also can have these situations arise where an employer may decide, we want to engage in an early exit incentive plan, early retirement. That is another method by which employers can engage in these types of decisions. In the past, generally, employers have had to, when engaging in these types of reductions in force, furloughs, anything like that, employers have had to look at what are the impacts of these decisions. Are our decisions of having a disparate impact upon a various protected job category? That's something you will still have to consider. Now, if you truly have a voluntary early exit incentive plan that you use for reduction in force, and you follow the appropriate rules under both the Age Discrimination and Employment Act, the Americans with Disabilities Act, and Title VII, you generally have a voluntary plan and you don't have to worry as much about those types of issues. But if it is a good old-fashioned reduction in force, then you will need to look at, are my decisions having a disparate impact amongst various different protected classes? Another thing that employers are going to need to look at that they haven't had to look at before when doing these types of reductions in force is, what is the effect of the PPP? If you were an employer who took PPP funds, you need to proceed cautiously with any type of reduction in force. And by that, you need to understand what your window period is for bringing your employees back and using your PPP funds. And remember, the statute was amended last week, first week of June, and the employers are now going to have a longer time to use those PPP funds. So therefore, if you've taken those funds, you need to look at how a reduction in force may or may not affect your loan forgiveness. You also may have had employees who have been out because of the Family First Coronavirus Relief Act. When you're dealing now in the post-COVID-19 world, especially if you're doing an involuntary reduction in force, if you are going to have an effect amongst many people who took leave under the Family First Coronavirus Act, you will need to make sure that you are setting this reduction in force up or handling it in a way where an individual employee who is affected cannot claim that they were singled out and they were targeted because they took job protected leave under the Family First Coronavirus Act. Last but not least, employers still need to be cognizant of the WARN Act, the Workers Adjustment Retraining Notification Act. As employers engage in reductions in force, if those reductions meet the thresholds and requirements of the WARN Act, then before an employer can engage in those reductions in force, they have to provide employees with at least 60 days written notice of the layoff or plant closing. They have to notify the highest elected official in the locality and the state dislocated workers assistance program, which for most states is your unemployment office, and in Virginia it is the unemployment office. If you have employees who will be affected and the WARN Act is triggered and you have a labor union, you also will have to provide a written notification to the labor union and potentially engage in effects bargaining concerning those layoffs. Most employers, however, may not have to face the WARN Act, because if the reduction in force as a starting point is less than 50 people at a single site of employment, you're probably okay. But again, should you get to the point where you believe you are close to WARN Act triggers, you really should get with your lawyer, discuss it with your lawyer, and understand what steps you may need to take to mitigate that risk. While this would not be a pleasant process for an employer to face, many employers will be evaluating reductions in force to maintain the economic viability of their companies and perhaps make the companies stronger in the post-COVID-19 world. Thank you for your time. Please make sure you visit williamsmullen.com for more ideas and best practices. In the coming weeks, there will be additional presentations. And if you have any questions as to my presentation, you can feel free to give me a contact at dburton or dburton@williamsmullen.com or on my direct dial 757-473-5354. Thank you and have a nice day.